Hello, everyone. Welcome back to our channel, Immigration YT TV. We hope you're doing great. In this video, we're going to talk about laid off H1B workers receive deportation notices despite 60-day grace period. What's going wrong? Hundreds of laid off H1B visa holders are receiving unexpected deportation notices even though they are still within the 60-day grace period legally allowed to find new jobs or change status. This video raises serious concerns about processing errors and inconsistent immigration enforcement. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So without any further delay, let's jump into the video. When an H1B professional loses their job in the United States, the rules allow for a 60-day grace period to find another employer or change visa status. For years, this policy has been a safety net for skilled workers navigating unexpected layoffs. But a growing number of H1B visa holders who were laid off recently are finding that this legal cushion may no longer offer the protection it once did. Many of them, despite filing proper applications within the grace period, are now receiving notices to appear, which initiate formal deportation proceedings. These workers, already dealing with the uncertainty of job loss and visa timelines, now find themselves in an even more precarious situation, facing potential removal from the U.S. despite doing everything the system requires. Playing by the rules, but still at risk. Laid-off H1B workers are taking all the expected steps, submitting timely applications to change their status, consulting legal counsel, and following government policy. But in many cases, NTAs are being served before USCIS has even made a decision on their pending application, effectively labeling them as out of status while they are still in a legally recognized, authorized stay. What makes this situation especially difficult for workers is the lack of clarity. For those who acted quickly to file a change of status, whether to a B2 visitor visa, an F1 student visa, or an H4 dependent visa, the expectation was that their lawful presence would be maintained until a decision was reached. Instead, they are now being treated as if they have violated their visa conditions. For these professionals, many of whom have spent years contributing to the U.S. workforce, this is more than a bureaucratic glitch. It places their future, careers, and families in limbo. Legal contradictions fueling the crisis. USCIS policy, as of February 2025, states that NTAs should only be issued after an unfavorable decision and only if the person is out of status. That guidance clearly protects individuals with timely, non-frivolous applications pending, yet NTAs are being served regardless. According to data from USCIS, around 1,840 NTAs have been issued each week since February. A portion of these are now confirmed to involve workers who were still within their grace period or had pending applications that by all definitions kept them in compliance. This inconsistency between policy and practice has led to frustration among immigration lawyers and advocacy groups who are now calling for immediate clarification from the Department of Homeland Security. Consequences beyond paperwork. The issuance of an NTA has serious legal consequences. Once someone is placed in deportation proceedings, their stay is no longer considered lawful, which can trigger bans on re-entry if they leave the country. It can complicate or prevent future visa applications or green card processing. It increases legal costs and forces individuals to attend immigration court hearings, often while still trying to regain employment. For workers who have been in the U.S. for years, the threat of removal creates emotional distress, logistical chaos, and long-term damage to their immigration record. Uncertainty without answers. As of now, USCIS has not issued an updated guidance to address the spike in NTAs during the grace period. Immigration experts say that without intervention, more H1B holders will continue to fall into this gray zone, compliant on paper but still subject to removal proceedings. In the absence of clear communication from federal agencies, laid-off H-1B workers are left relying on legal advice, online forums, and peer experiences to make sense of their situation. Many are now hesitant to file for status changes out of fear that even a timely application won't protect them. What workers can do. Immigration attorneys are advising all affected workers to file status changes as early as possible within the grace period, keep all documentation and USCIS receipts carefully organized, monitor mail and USCIS case status closely, seek legal counsel immediately if an NTA is received. While these steps may not eliminate the risk, they can help build a case if removal proceedings are initiated. What's at stake? This issue goes far beyond paperwork delays or internal miscommunication. It represents a breakdown in trust between the immigration system and the skilled workers who fuel many of the U.S.'s most critical industries. If not resolved, this trend could deter global talent from coming to the U.S. or staying here after years of education and contribution. At a time when countries like Canada, the UK, and Australia are actively attracting skilled immigrants with clearer pathways and protections, the U.S. risks losing its competitive edge. As anxiety grows among skilled foreign workers, advocates are urging USCIS to clarify procedures and protect legal rights during the grace period. Without swift correction, the U.S. risks losing high-skilled talent to confusion and mismanagement. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.